Welcome. In this module, we will explore the fundamental legal and administrative aspects that every physician must know to open and operate a private practice in Mexico. While our training focuses primarily on clinical care, it is crucial to understand that medical practice, especially in the private sector, does not occur in a vacuum. It is surrounded by laws, regulations, technical standards, and tax obligations that provide structure, legitimacy, and safety to our work. In Mexico, practicing autonomously, ethically, and safely requires more than just knowing how to diagnose or treat diseases. We must also understand how to comply with the requirements demanded by the legal framework. Throughout this session, we will address the essential regulatory elements, from health permits to tax requirements, and from physical infrastructure to proper documentation management. This knowledge is useful not only for avoiding penalties, but also for strengthening the quality of care and the trust patients place in us. Although we will delve deeper into many of these aspects later in the course, this presentation will provide a clear and practical overview. It is the first step toward viewing outpatient medicine as a comprehensive professional endeavor, one that integrates legal and administrative compliance as an essential part of good medical practice. Opening a medical practice in Mexico requires more than just a professional degree in physical space. There is a specific set of legal procedures that must be completed with various authorities to ensure compliance. One of the most critical is the Notice of Operation, or Aviso de Funcionamiento, filed with COFEPRIS. It is important to understand that this is not a request for a permit, but a mandatory notification stating that a healthcare facility is commencing operations. Failure to complete this procedure can result in the immediate closure of the practice during an inspection. Another key requirement is the land use license, zoning permit, issued by the corresponding municipality or borough. This document guarantees that the premises are located in a zone authorized for medical activities. Simply put, not every commercial space is legally suitable for a doctor's office, even if the location seems ideal. Additionally, the property must have a civil protection certification. This ensures the facility meets basic safety standards, such as having emergency exits, fire extinguishers, and proper signage. This is vital for managing any incidents that could put patients or staff at risk. Finally, you must possess valid proof of possession. This means having a formal lease agreement or documents proving property ownership. This documentation is essential for both administrative procedures and the formal legitimacy of the business. These requirements are mandatory, regardless of the scale. Whether it is a small private office or a clinic attached to a pharmacy, the rules apply. Medical practice is not exempt from the law, and compliance with these aspects is an integral part of our professional responsibility. Moving beyond paperwork, we must address the physical facility. Once the legal procedures are covered, the next critical step is ensuring the medical office meets the minimum infrastructure and hygiene conditions required by Mexican sanitary regulations. First, the layout must have clearly defined functional areas. This includes a waiting room for patients, the actual consultation or examination room, a restroom, preferably accessible, and, if applicable, specific areas for performing procedures. Furthermore, the facility must maintain strict hygiene standards. This implies having washable walls, flooring that is easy to disinfect, proper lighting, and either natural or mechanical ventilation to ensure adequate air circulation. Regarding equipment, there is a mandatory basic checklist. This must always be present and includes an examination table, weight scale, sphygmomanometer, stethoscope, thermometer, and minimum supplies for wound care. Waste management and emergency preparedness are also non-negotiable. You must have specific containers for RPBI, hazardous biological infectious waste, such as blood-soaked gauze or used needles. Additionally, unless the office is located within a hospital unit, it must be equipped with a basic emergency kit. Even if you do not offer emergency services, you are obligated to provide basic care if a patient arrives in a critical situation. We also cannot overlook general safety measures. Items such as fire extinguishers and clearly visible evacuation route signage are mandatory. While these may seem like minor details, they are indispensable for the protection of both patients and staff. Compliance is not optional. The official Mexican standard regulating these aspects is NOM 005 SSA 32010. What we often view as minor bureaucratic details are, in reality, key indicators of a physician's commitment to safety and quality of care. Now let's address the fiscal side of the practice. Practicing medicine in a private office implies becoming a formal taxpayer before the Service of Tax Administration, known in Mexico as the SAT. The first step is enrolling in the Federal Taxpayer Registry, or RFC. This registration is indispensable. Without it, you cannot legally issue invoices or comply with the corresponding tax obligations. Regarding the tax regime, most self-employed physicians fall under a specific category. This is known as the Individual with Business and Professional Activities regime. This means that legally, even though we are practicing a profession, the authorities view us as a small business. Therefore, strictly tracking income and expenses is mandatory. Once registered, issuing electronic invoices, known as CFDI, is required. You must issue one for every service or consultation provided. It is important to understand that this is not optional, nor is it a favor to the patient. It is a strict legal responsibility. You are also required to file monthly and annual tax returns. In these filings, you report income and deductible expenses to calculate taxes owed, such as income tax, ISR, and value-added tax, IVA, if applicable. While it is common practice to hire an accountant to facilitate this process, you must remember that the legal liability ultimately remains with the physician. We might ask ourselves, what happens if we fail to register or invoice? The answer is simple. We are committing tax evasion. This can lead to heavy fines, audits, and even the closure of the practice. Beyond the legal repercussions, failing to comply damages professional reputation and patient trust. Compliance is a matter of ethics. Fulfilling our tax obligations is not merely an administrative burden, it is part of medical ethics. Transparency, legality, and commitment are also reflected in how we manage the business side of our practice. One of the cornerstones of responsible medical care is proper documentation. It is not merely a legal formality, it is a fundamental clinical, legal, and ethical tool. First and foremost, every patient must have a complete clinical record. Known in Mexico as the Expediente Clínico, this file must be up-to-date and securely stored. It encompasses everything from initial medical notes and test results to progress notes and informed consent forms for procedures involving risk. The official standard, NOM 004 SSA 32012, clearly establishes the rules. This standard dictates how records must be structured and preserved. Relying on a simple notebook or loose sheets is insufficient. The standard demands order, clarity, chronological sequence, and strict confidentiality. Informed consent is another critical component. This applies particularly to minor procedures or those carrying specific risks. It is not just about obtaining a signature. It is a process ensuring the patient fully understands and voluntarily accepts a procedure or treatment. This process must always be documented. Furthermore, effective management improves safety. Maintaining efficient control over appointments, follow-ups, and medical notes does more than improve service quality. It prevents errors, omissions, or misunderstandings that could escalate into medical or legal complications. We must also consider retention periods. Clinical and administrative records must be safeguarded for a minimum of 5 years and remain accessible solely to authorized personnel. Think of this as your safety net. Let's imagine a scenario where a complaint or lawsuit arises. How can we defend our actions without proper documentation? This highlights the true importance of this topic. Thorough documentation is also our best form of professional protection. Growth brings new responsibilities. When a medical practice expands or simply seeks to improve care, it is common to incorporate auxiliary staff, a receptionist, a nurse, or cleaning personnel. While this might appear to be a simple administrative step, it actually represents a major structural change. The office becomes a workplace. From the moment you hire staff, the practice transforms into a formal workplace. The head physician, the person directing the clinic, assumes a new role, that of an employer. This requires formal labor relationships. What does this entail? It means having written contracts, registering personnel with the IMSS, Mexican Social Security Institute, and strictly complying with statutory benefits such as paid vacations, the year-end bonus, known as aguinaldo, and ensuring decent working conditions. You are liable for your team's actions. The head physician holds legal responsibility for the conduct of their staff. For instance, if a nurse makes an error due to a lack of training, the liability falls upon the person running the practice. Supervision is not a courtesy, it is a professional obligation. Continuous training is essential. Therefore, it is crucial to train the team continuously on topics such as biosafety, patient care, waste management, and emergency protocols. Constant education is a fundamental part of good medical practice. Chain of command. Even if multiple doctors rotate through the office, there must be one specific figure who assumes regulatory and administrative responsibility. This cannot be left to chance. The whole experience factor. It is worth asking, how many times has a bad experience with reception or staff caused a patient never to return, even if the doctor was excellent? True quality extends beyond the clinical. The quality of a medical practice is not measured solely by clinical outcomes, but by every interaction, every process, and how the human team sustaining it is managed. We now turn to an essential, yet often underestimated, component of operations. Proper waste management and adherence to basic biosafety measures are critical for any medical office. Not all waste is created equal. We must strictly classify waste into 3 main categories. First, common waste, items such as paper or clean wrappers. Second, RPBI. This stands for Residuos Peligrosos Biológico-Infecciosos, hazardous biological infectious waste. This category includes blood-soaked gauze, biological samples, or contaminated materials. Finally, sharps. Items like needles and scalpels must be disposed of in specific rigid, resistant, and labeled containers. The rules are clear. The official standard NOM 087 SSA1 dictates how these materials must be handled. Among other requirements, it mandates that RPBI must be collected by authorized companies that provide official evidence of proper disposal. Placement matters. It is also mandatory to have specific, clearly labeled bins located precisely in the zones where the waste is generated. This is a protective measure for everyone, staff, patients, and visitors alike. Biosafety extends beyond waste. It includes daily protocols such as hand washing before and after every consultation, surface disinfection, adequate ventilation, and the use of gloves or protective equipment whenever procedures require it. Professionalism is in the details. We sometimes hear that these measures are exaggerated or unnecessary for a simple checkup. But the truth is, these actions are a direct reflection of our professionalism. Consider the patient's perspective. How would a patient feel if they saw their doctor throw a used needle into a regular trash can? Or if they detected unpleasant odors due to poorly stored waste? The impact is both perceptual and ethical. Taking care of these details means protecting health, preserving trust, and safeguarding the professional image of the practice. Safety within the practice is not a trivial matter. It is both a legal obligation and an ethical necessity to guarantee that patients and staff can move and exist within a safe environment. Let's talk about the most visible, yet most forgotten element: mandatory signage. You must clearly display signs such as no smoking, evacuation route, emergency exit, and any others indicating risks or safe zones. Equipment readiness is also non-negotiable. The office must be equipped with functional fire extinguishers, placed in accessible locations with their inspection tags fully up to date. Furthermore, it is mandatory to have a first aid kit that is complete and readily available for any eventuality. We must also inspect the guts of the facility. I refer to the condition of electrical, gas, and water installations. It is not enough that they simply work. They must be in safe condition, free of improvisations, overloads, or leaks. We must remember that many accidents originate from deficient facility maintenance. Preparation is key. An evacuation plan must exist, regardless of how small the office may be. This plan must be clear, communicated effectively to the staff, and emergency exits must remain completely free of obstacles at all times. Let's picture a common scenario. How many times have we walked into an office where the fire extinguisher is covered in dust, blocked by a chair, or where there isn't a single visible sign indicating how to evacuate in an emergency? This reflects on you. Beyond complying with a standard, these conditions reflect a professional and proactive attitude. They remind us that practicing medicine also implies caring for the physical environment where we treat people. A look ahead. Do not forget that this connects directly to clinical and non-clinical risk management, a topic we will explore later in the course when we discuss quality and patient safety. Not all medical practices operate under the same model. Although every facility must comply with the exact same sanitary, legal, and fiscal regulations, today we typically encounter two very common models: the independent private practice and the pharmacy-adjacent clinic. Let's look at the independent practice first. This model operates autonomously. Here, the physician or group of physicians is directly responsible for every single aspect: administrative, clinical, and financial. While this offers greater control over the practice, it also means assuming all the obligations and risks. On the other hand, we have the pharmacy-adjacent clinic. This model has seen exponential growth in Mexico. It functions either inside or right next to a pharmacy, usually under specific commercial agreements. However, even if the space is provided by the pharmacy, the medical responsibility remains exclusively with the professional providing the care. This brings us to a delicate point: conflict of interest. When the place where medication is prescribed is the same place where it is sold, there is an inherent risk that clinical decisions could be influenced by commercial objectives. We must ask the hard questions. What happens if every medication prescribed happens to be the same brand the pharmacy sells? Or if the doctor feels pressure to prescribe more just to justify their position there? These are rhetorical questions, but they are very real, inviting us to reflect deeply on medical ethics and professional autonomy. Regulation is tightening. COFEPRIS has issued specific guidelines for this type of clinic, and in some states, even stricter controls or additional registries are now required. The bottom line: it is crucial to understand that no business model exempts a physician from legal and ethical liability. Whether in an independent office or one attached to a pharmacy, the person attending to the patient is the one directly responsible for their care. We have reached the end of this journey. We have reviewed the essential legal and administrative aspects that must be met to open and operate a medical office in Mexico. Medicine is more than clinical work. As we have seen, practicing outpatient medicine is not just a clinical decision. It is also a legal, administrative, and profoundly ethical decision. Every procedure, every document, and every standard we must comply with. These are not obstacles. They are tools that allow us to practice with safety, quality, and professionalism. Compliance is not a burden. It is a way to back up our work, protect ourselves, and generate trust in our patients. When an office is well documented, well signposted, adequately equipped, and properly managed, what it projects is commitment. Context matters. This is not just about avoiding sanctions or audits. It is about us, as physicians, taking the environment in which we practice seriously. Medicine does not begin when the patient enters the door, nor does it end when they leave. Think about it for a moment. If you were to open your own office tomorrow, how would you visualize it? Orderly, regulated, and professional? Or improvised, undocumented, unregistered, and unsafe? The invitation is clear. We must build an integral vision of medical practice, where the clinical, legal, administrative, and ethical align to benefit who matters most, the patient. A note on what comes next. Please remember that what we have covered here is a class summary. This topic is just the starting point. In the book, you will find this information expanded in greater detail. While the subject matter can be complex, the goal is not to offer a rigid step-by-step instruction manual, but to synthesize and explain the reality that awaits you. We want to arm you with the basic, essential knowledge needed to face the real world, understanding that medicine is not only a science but also a legally committed act.